Information overload, and that is putting it lightly. Hey guys, this is Jules with True Crime Reactions. We had an extremely important hearing in the Idaho 4 case take place yesterday, Friday the 18th, and there were 4 expert witnesses that ended up giving testimony. One of them was extremely last minute, but I will state right off the bat that I believe that Gabriela Vargas is a badass. We're going to get to what she had to say later on. Mercer, who is not a scientist, but is an attorney that has worked with cases that have to do with forensic DNA, and he has been appointed several positions in different departments and has worked in state and federal levels when it comes to cases that have to rely on forensic and genealogy type information and evidence to have the cases solved. And he's been doing this for quite a while out of Maryland and in that district. And he's, like I mentioned, also been in federal courts working on forensic type cases. So he knows the standard of practice that should be used when it comes to an attorney making sure that they are properly doing their job for their client. And according to Mercer, in order for the defense to properly do their job in defending Bryan Kohberger, they should be allowed all of the IgG information because the S&P profile needs to be validated by the STR profile and vice versa. And these two things cannot be looked at separately. It all has to be looked at in a combined grouping in order for everything to be validated. And right now, according to Mercer, the defense team doesn't have that option because none of the information for the IgG is being given over, and it's been nothing but a huge fight. Now, after Mercer, we then had Larkin come up, and she came out with an entire PowerPoint presentation that I believe from the live Twitter feed that I was posting on YouTube yesterday. They ended up taking a recess so that everyone could look over the PowerPoint presentation, and then they allowed a lot of it to be shown in court, and it was actually explained very well. Now, I do have a background in criminal forensic science, and I'm like a science geek. Science was my favorite subject in class, and I get really super into the details. So I actually went back and listened to a lot of what Larkin had to say, and she was talking about mitochondrial DNA and the Y chromosome DNA and the way that the two work together and the differences in the amounts of DNA that's needed for like actual ancestry genealogy work versus what's needed when it comes to criminal evidence, when it comes to the amount of DNA that's needed for certain things. And I think that's really, really important because I have from the beginning questioned how with this little bit of DNA that we're being told that they actually did find and the type of DNA that it is, that they had enough of the sample to be able to do all of the testing that they're claiming to have done. Because you can't just take like results of things or reuse samples. Every single test that is ran has to use a fresh sample, and multiple tests have to be ran multiple times, and a certain percentage of validity and reliability has to be met before it's even considered a successful test. And it has to be met several times in order for it to be a valid result. It's not just a one and done situation. So that's why I've always questioned, how are they able to run all of these tests in all of these different departments and with all of these different agencies that did all this testing? How was it possible that they had enough of it? Well, Larkin actually does give like an alternative way that things can be taken out of like degraded or low level amounts of DNA. She's like, when it comes to the genealogical side and the ancestry.com type testing, you spit in a tube or you swab your cheek. But it's put into like a preservative and it's like not a contaminated source. But whenever there is possible contaminations or whenever there is issues of the sample being not a lot, like just some particles like in touch or trace DNA, then there's something that can be done that's called next generation sequencing. And it is actually pretty interesting. But I did find it pretty common that what everyone's basis is that the SNP and the STR have to be combined and looked at together. They can't be done separately. And that's a huge thing, especially whenever you go into the way that the ancestry and the genealogy stuff is actually done, because all of these family trees basically have to be reverse engineered to where, you have these certain matches, but you have to find how matches actually link up to other matches before you can detail how your person of interest is actually involved in that family tree and how they connect into that family tree. It's really a lot, and I'm not the best teacher on how to go back and like regurgitate all of those details. So I will just suggest that if you want to get the real detailed information that they were putting out on the way that these tests are actually conducted and what's needed and the steps and the levels to get to the result, I would suggest go back and actually listening to the hearings, because they literally do not skip a beat in making all of these protocols and procedures very, very clearly known. And it's really sort of impressive because a lot of these things are like self-taught, because all of this became really relevant in solving cold cases and current cases and solving people that are looking for their parents and missing children's cases and John Doe cases and adult and babies, which, is what Gabriela Vargas comes out and speaks about. All of that, when it came to finding, familiar matches and relatives to the suspect profile that they had, all of that became extremely important in doing a lot of very, very, very official things before there was ever any credentialing or certification available or any kind of class that you could take that said that you were an expert on it. It was kind of something that scientists and, detectives together basically just started looking into, and it became popular for people to try to figure out where their ancestry came from. And that's another thing that Larkin gets into, is she talks about how, there's these direct to consumer type databases, and then there's certain ones that have certain protocols that only law enforcement can utilize, that is a whole lot more restrictive than if you were just a person uploading a profile or getting your DNA taken for some sort of testing. You have a more wide range of access as a person of the public than you do as an actual law enforcement official. So I'm glad that there are protocols in place, but Vargas goes into a lot more detail when it comes to the loopholes that things like GEDmatch have, the loopholes that places like My Family DNA or My Heritage have, that law enforcement can technically go around to view not only profiles that have opted out of sharing their information with law enforcement, which is unethical and illegal, but these loopholes are there. Not only that, but to also be able to get a more broad spectrum view of a match to a DNA profile by law enforcement pretending to just be a regular person uploading their information, because they know that if they use the law enforcement portal or law enforcement access, then they're not going to have that full spectrum view of all of the possible matches for their person of interest. And that is something that was placed in Vargas's declaration that was filed, I believe, on the 17th. And I asked in my video about it, is this a direct statement or is this a general statement based on her history? At this point, the way that she is coming across things and the fact that it seems like I don't know how much information that she's been shown. What she claimed is that someone involved in the case, but she didn't give any names, reached out to her asking if she'd be willing to talk to the defense. And when she got on the Zoom meeting with the defense, all she did was give her credentials and like explain to them everything that she's done, the cases that she's worked on, and the processes that she uses. And that was basically it. So I don't know how much she's actually seen, But then again, what could she have seen? Because the state doesn't have any of the work, which is what the original argument from Mercer, the first expert witness, was talking about. How the defense can't properly do their job if they're not able to go in and validate that all of the genealogical information was obtained correctly. Not just the testing itself, but how it was obtained to find the match that got them to Brian all the way in Pennsylvania. And also, according to Mercer, in all of the states that he has worked in, when it comes to all of the information that gets given, when it comes to how the family tree and the suspect profile was matched up to said family tree to get the person, he's claiming that when it comes to the information that is supposed to be shared, it's supposed to be all of the raw data plus all of the protocols, all of the bench notes, how the profile was generated, and all of the discovery about how the profile was searched in different databases and exactly how the family tree was constructed. All of it is needed. The S&P and the family tree cannot be looked at separately. You cannot be given an S&P profile and then been given a family tree claiming that this is where this leads to your suspect separately. You have to be able to validate that they actually combine together perfectly. You know, kind of like those missing puzzle pieces that a lot of us still feel that we don't have in this case. Same concept. What I found really interesting about the information that Vargas was telling us is that it matched a lot of what the defense has kind of stated, a few months ago before they even contacted Vargas, about how they felt as if law enforcement was trying to hide the way that the information was obtained because they didn't want the public to know the way these websites actually conduct themselves or even the way that law enforcement uses these websites to conduct business, right? And she brought up the fact that a lot of the things when it came to information being shared, opting in, opting out, all of that stuff was changed after the way that the Golden State Killer was found. Now, GEDmatch apparently has a pop-up that says, do you want to opt into law enforcement sharing, yes or no? But when My Family Tree, if you upload to My Family Tree, there's no pop-up. You have to just automatically have it in your brain that you need to go to the settings and toggle that on or off. And your normal layperson who's just following instructions on a website isn't going to know those little extra steps. So a lot of people, I feel, kind of get tricked into sharing information with law enforcement. I mean, okay, even though the argument can be, okay, if you've done nothing wrong, then you should want to help to solve cases and whatnot, okay, which is fine. But if I'm not asked for that and my information is just taken without my knowledge, I'm not okay with that. Now, if someone came up to me and a law enforcement agency needed my DNA to solve some sort of cold case because they think that my linking could get them closer to the suspect, sure, here's my arm, take it, what you got to do. But when it comes to stuff like this is a death penalty case. Every little step, every little cross of the T, dot of the I, everything, there shouldn't be any questions or big fights on sharing that information if it's legitimate information. And it goes for both sides. It really does. And we're going to get into the whole alibi argument here in a minute too. But that's what I mean by it goes both ways. You can't expect one side to just give you every little thing that you're asking for, but then constantly give pushback and not give them what they're asking for either, which is why we're seeing all of this. Oh, and I will say, it took me like 3 different channels to be able to actually watch this entire hearing at length. Because Court TV, when they were playing it yesterday, it was basically like watching cable. So there was all these commercials and stuff in between, and a lot of it was being talked over. And so a lot of it got missed, honestly, which is another reason why I was following the News Nation guy on Twitter and posting his updates from inside the courtroom on my community tab. And if you guys haven't seen that, all of those are still on there, or y'all can just go to Twitter and just follow the thread him, yourselves. But he had a lot of really good information that he was putting out to Twitter while we were having all these weird breaks in the courtroom. So after a while, we went over to watch it on the East Idaho News, which a lot of you guys know that channel from the Dylan Rounds case, but they were having a lot of issues. And then the very last part of all of the scheduling and stuff just was never uploaded to East Idaho News. So then I had to go find it on the Law and Crime Network. And it was so difficult to hear. It was so difficult to hear. I don't know where all of a sudden hurricane winds came from. But almost everything that Barlow was trying to say was completely unintelligible. It took me, I don't even know how many times of listening to her just to try to get a little bit of information. But what she had to say, it didn't really seem like it was anything too much different than anything else that we'd already heard, honestly. She was kind of just giving the same opinion that Mercer and Larkin and Vargas seem to have about how important the steps taken with the genealogical testing that got them to Brian is. So that wasn't a big deal. And when I finally, when it finally got to all the scheduling and all of the motions being approved or denied, it was clearer to hear. But I don't know how, this case has been funded with so much money and they can't even. Actually, you know what? It's not even the court's fault. This is court TV and their crappy recording equipment. Like, come on. Come on. Now, of course, the motion to stay was denied, which I pretty much figured it was going to be denied. But now we have this huge schedule of things. It is going to be a very, very, very busy next few weeks. Like, legit, just take a vacation because this is going to be pretty ridiculous. So it took a while for them to kind of get the schedule down, and hopefully I have all this right at this point because they kind of went back and forth with a few dates. But I tried to get the schedule down as much as I possibly could, and they should be coming out with all of these documents that have the dates for all this stuff pretty soon, but this is what we have for right now. As of the date of this hearing, which again was yesterday the 18th, we are 6 weeks away from trial, and the judge is adamant that at this point, even though there's a list this long of things that needs to be done, trial is starting on October the 2nd, okay? The very first deadline that we have, Ann Taylor made it clear in court that there is now a second motion to dismiss that is pending filing, and the judge gave them a deadline of August 23rd to get that filed, but also on August 23rd, they've scheduled a status conference that's going to be taking place in person around 2:15 p.m. I don't believe that we get views of the status conferences. I think we just kind of get information posted on the official website after the status conferences are done, so I don't think that there's going to be anything that we need to view for that. On the 30th is whenever the state has to officially respond to the second motion to dismiss that gets filed on the 23rd. So the state is going to have 7 days to respond to the second motion to dismiss. Now, apparently on September the 1st is the deadline for the completion of discovery. And that's whenever the motion to dismiss was originally going to be talked about. From what I'm understanding, it's going to stay on September 1st, even though the state's deadline to respond to the second motion to dismiss is only 2 days prior to that. But the state said, whatever, let's just do it. So on the 1st, not only is the completion of all of the discovery have to be done, but this is also whenever the motions to dismiss are going to be talked about. And the timing that they have on here is 1 p.m. Again, I don't know if that's something that we're going to be able to watch or not. We'll find out whenever it gets closer and documents start getting posted. Now, September 8th is the deadline for any expert disclosures. Any proposed lay witnesses, meaning friends, family, or any eyewitnesses that are expected to be talked to and need to testify. It's also if there's an actual alibi. Okay, now this is what I'm talking about. When I was mentioning how, you can't just... Basically, they're both fighting fire with fire. They're acting as if the state has all this stuff that they're not giving over, and the state is like, no, we're giving you every little thing that we have, minus actually there's one more lab report apparently coming their way. One lab report, which is whatever. But when it comes to the alibi, Brian has only said, yeah, I was out driving by myself at night, which is him admitting that it's a very, good chance that the car in the video surveillance that they're talking about in the PCA is him. Because he's admitting that he was out driving from the 12th through the 13th. He gives a wide range of time, and it's just, I'm out driving in the middle of the night by myself, basically. Well, the state's like, okay, well, if you don't want to give us people whatever, at least give us places. Where were you driving around? Do you not know the area that you were driving in, the streets that you took, the highway that you were on? They want a little bit more specificity, which I don't blame them for, because if you're going to produce an alibi, then at least try to meet the standard that the state's asking you to meet. And while, yes, it is a sort of alibi, even the judge admits in whenever they're giving the dates for the scheduling, if there is an actual alibi, then you have until September 8th to give us your location, your witnesses, their addresses, and basically to know if they're going to testify or not. So if there's any actual information besides I was driving around by myself in the middle of the night and no one can say otherwise, then they only have until the 8th to make it official. The state was pretty adamant about not wanting any third party alibi evidence to be accepted. If there's an actual alibi, you need to give us the details. And this is the deadline to do it. Okay. Also, the deadline for pretrial motions, motion of limine, anything for the death penalty, and if Brian KOHBERGER, for some reason, decides to waive his right to a speedy trial, all of those things need to be filed by the 8th, because on the 15th is whenever any responses to those motions need to also be filed. Now, we know at this point, it's just talk that the IGG information is not going to be included. Okay. The official motion of limine that actually excludes it from trial has not yet been filed, at least not that I have seen. And if it has and I missed it, please correct me in the comments. But that has to actually be filed with the court in order for it to not be like contested and to actually be excluded. And that's pretty important because right now a lot of stuff in this case has been circling around the IGG that's not even supposed to be admissible in court according to the state. I'm kind of curious as to why they're taking so long to file the motion of limine, because it's been in talks about that's what their plan is for months now. So I'm just curious as to what the tactic is for not having already filed it and allowing all of these things to come out circling that subject that they don't want to even have. You know what I mean? It's what's taking so long? Just file it already if that's what your intent is to do. Now, also on September 15th, and I'm looking over at my notepad over here, they have to enter in any of the proposed juror questions that they want asked to the jury selection when it comes down to that. They also want responses to any of the lay witnesses that are admitted by the deadline of 9/8. Also, they want responses to any of the expert disclosures that are deadlined to be filed by 9/8. And they also have a deadline of 9/15 for sentencing and mitigation and any and all notices. Because on September the 22nd at 10 a.m., any and all remaining motions that need to be discussed are going to be heard on this day and hopefully done and over with and handled on this day, and there's nothing else that has to happen. Because on the 25th is whenever they're going to start the jury selection. The judge says he knows for a fact, or he just has a feeling, that it's going to take the entire week to get the jury selection completed. And he's calling the 25th through the 27th the first steps for the death penalty qualified jury selection. And they are initially calling in 1,000 jurors. Okay. So then on the 29th at 10 a.m. is the final pretrial conference. And then, of course, the trial is set to begin on October the 2nd and run through 11/17. Which I have an issue with because the anniversary of this situation is going to be like the final Monday, the very beginning of the final week of court. So that's going to be an interesting day. But 4 weeks of it is at least supposed to be trial, with 2 weeks of it being left to sentencing. That is the schedule for now. Now, I will say on some of the arguments that the defense and the state made, let's talk about the DNA, because the additional unidentified DNA profiles were brought up in here, and it seemed like Santa Claus had an issue with these being brought up. And honestly, I have an issue with the fact that there's still to this day unidentified profiles. I can sort of let them make it on the one that was found outside, But whenever you have two additional profiles inside the home, it doesn't matter if it was in the bedrooms, if it was in the kitchen, it doesn't matter. It doesn't matter. If you have additional unidentified DNAs in a case, and as of the date that you were working on the DNA profile of who you are now calling your person of interest, your suspect, the person that you're trying to put in front of a firing squad, if on that exact same date you still had all of these unidentified profiles, and by all of these I mean 3, what made you not do any workup on those profiles and focus just on this one? And what I really would like to know, because I don't know, what the hell does Santa Claus mean when he says they were told that those DNA samples were not eligible to be placed in CODIS? What the hell does that mean? What is not being able to be ran into CODIS because it's not an eligible sample mean? Does it mean the type of sample that it was? Does it? I don't understand. You're investigating an active quadruple unaliving. Thanks, YouTube. And you have obviously surveilled other people to where you've taken a cigarette butt and done DNA testing on things, and it took you a while to get to where you are now. And the steps that you took to get to where you are now aren't making clear sense to pretty much anyone. And what it seems, including yourself, the state seems like they don't even know what's happening, guys. If you really sit back and you look at the way that they respond to things, Santa Claus just throws his arms up. I don't even know how many times. He doesn't know what to do. Exasperated is the term that I think when I watch the way that he moves around whenever he's answering these questions. And it seems like the problem that they're not understanding, okay, the state is sitting here saying the defense was all these things that they just don't exist. They're not real. We can't give them over because they don't exist. Well, that's the problem. These things should exist. There should be workup to be reviewed. There should be workup that the defense knows exactly which path they need to take in order to validate the workup. And that was one of Mercer's arguments, that the defense needs to see the type of testing that was done. And they verify at the end of this that they don't know whether it was whole genome sequencing or this next generation sequencing that was done. And there's a huge difference in the way that these things are tested. And the way that this was actually done would determine the type of expert that the defense would need to obtain to validate and double check the work that was done. And that's a valid point to me. I mean, I understand that part. But when it comes to the other arguments, when it comes to the DNA profiles that have just been left unidentified, why is the big question to me. Because you at that point didn't even know where the DNA on that knife sheath was going to lead you. How do y'all not know if those DNA samples belong to your suspect? Because there is a possibility, guys. There's a possibility that these unknown DNA samples could be Brian's, but they don't know because they haven't done any workup on them. So they're just being classified as unknown male DNA. Okay, but was that DNA ever tested up against the suspects? We don't know. Was that DNA ever tested up against anyone? We don't know. If it's being labeled as unidentified, I'm going to assume that they did do matches to this DNA against something, but was it up against Brian's? I guess I don't know if we're ever going to find out, but I would like to know. And if it's unidentified, I mean, I kind of get it. It was a party house. Lots of people went in and out of that house. Some that the people that lived there didn't even personally know. Okay, I understand that. But there still should have been just as much workup done on the DNA samples that were found as there was on Brian's, because y'all didn't know at the time where any of that was going to go. So yeah, in my opinion, the exact same workup, at least to a certain point, should have been done to validate who those samples actually belonged to. And I honestly feel like the defense has a good argument there. I feel like the defense has a good argument when it comes to that and when it comes to the IgG. I feel like if it was obtained correctly and the state has confidence in it, then why not just give it to them? And that's something else that the defense brings out at the end of this whole situation, at the end of the hearing, is that the fight that they're having to put up just to get something that other states willingly give over with no problem is a huge suspicion. And it seems like the judge kind of agreed. So I don't know really at this point if the IGG information is going to be forced over or not. But I don't even know if they can, guys, because according to what we're getting from the state, the FBI didn't hand over any actual workup. They just kind of handed them the results and was like, "Here you go. Now go prove it." So I don't know how this argument can go because, you know, the state's correct. The defense is sort of asking for things that technically don't exist, but the defense is also right in asking for those things because in, lots of states, they exist and are willingly handed over. I don't know. Now, when it comes to the grand jury stuff that they're trying to say there's errors with in their original motion to dismiss, I feel like that's just a bunch of like nitpicking nothing, especially now that I listened to the way that Ann Taylor kind of described it. Because she was talking about, oh, there was an error on all of the forms for all of the jurors. There's the same error up in the corner somewhere. And I'm like, okay, well, if you're going to use that as a fight for this one, then you basically have to go back and fight like all of the grand jury indictments since that form ever started being used. And that could go back how many years? So that felt like a bit of a reach. And I know that there was some sort of issue apparently with some juror not checking the box on if they spoke English or not. But, if the rest of the form that was given in English is answered correctly without without skipping a beat, then it's pretty obvious that person understands and speaks English. So again, more like nitpicky type stuff. And another thing that she mentioned is that 45 jurors for the grand jury were actually issued out or like called, summoned to be like selected, but only I think she said 32 were actually kept. And she tried to make that seem like it was a big deal, but we all know how that works, right? Like jurors get called and there's a certain number that get called and there's all kinds of things that happen that like shorten that jury list. Either you're not qualified for some reason, something in your background, something that you do for a job disqualifies you, someone that you might be friends with or related to or maybe even work with because you have a connection to somebody who might know somebody else might disqualify you. You could disqualify yourself. You could literally ask not to be there. You could just not show up. Okay, there's a million different things that cause that original number of the jury pool to then be dwindled down, which is another reason why I'm sure they've decided to start this DP jury trial selection with 1,000 people. There's going to be a lot of stuff going on that week. Those people are going to have some interesting stories when all this is said and done, I'm sure. So I felt like the defense claiming, 45 were asked for and only 32 were kept. Again, that's kind of like a duh situation. And that happens literally in every single type of jury. So there's nothing there. So when she said that there was a second motion to dismiss that had various things in it, I was like, okay, maybe this is going to be the substance that I've been expecting. Because I'll admit, I am still on the fence on this case. I'm not ready to claim whether I think that Brian is innocent or guilty. I know that there's apparently no connection between him and the victims. There's no evidence of the victims being anywhere in his apartment, in his car. And I don't mean physically, just like there's no DNA of them anywhere. He didn't have any noticeable injuries whenever he went back to school after the situation. And even if someone would have been, completely covered up with the mask on and, the way that there was no that's a whole other thing. Anyway, the way that they're claiming that he could have been suited up, okay, maybe scratches, all right, but what about bruising from like being hit back? Like there's no bruising anywhere. Nobody tried to punch him in the face. There was no black eyes, no busted lips, no cuts, no nothing to make it seem like he even gotten into a little bit of a tussle. So it's okay. And then we also have all this stuff with John Daniels and the 10 days that the blood evidence from his apartment wasn't given over or placed where it was supposed to be. And my biggest thing with that is this, like, this wasn't like this was blood evidence that was found in Pennsylvania that was going to have to go through this long, lengthy process of being brought all the way to Idaho. I mean, even if it was, we saw how fast they got the trash can DNA tested out, right? But this is like a 10-minute drive between Pullman and Moscow. And instead of Don Daniels driving over and just being like, hey, this is the situation, I'm driving over right now to bring this to you, it's all sealed up, and all of the chain of custody for that being validated and it be fine, she waited an entire 10 days to meet up with Ann Taylor at Brian KOHBERGER's apartment and then handed it to her. That's been a big problem for me, especially since Don Daniels is the one who asked for the DNA from the knife sheath not to be considered in the search warrant for the apartment. All of those things have just been very strange to me. And I know that we had a document where the judge even like hand wrote around his signature that there was questions around transport of evidence or something like that. But I haven't heard anything else about that being talked about. I'd love some information on that, Judge. What are you so curious about? What do you have questions about? Please, I need to know. But I think that that's it when it comes to recapping what happened. I'm not really having anything else pop up in my brain that's like blaring important to me that I need to mention. So I do think that that's about it. But what do you guys think after listening to the hearings, listening to what the arguments were, listening to the expert witnesses, all of these new dates and how busy things are going to be? I wish we had some more information about Bethany, and I wish we knew for sure if the defense actually ever went over there to actually talk to her, but I guess that's something that we're not going to find out until trial, unless some new documentation actually does get presented, which it does seem like, there's still a chance that there could be some really interesting new information when it comes to this second motion to dismiss that's going to be hopefully filed by the middle of the week. So I'll be interested for sure to read what is in that one. But yeah, there's a lot of dates coming up, so y'all are going to be seeing a whole lot of me because we are going to be talking about all of it as much as we possibly can and trying to figure it out. Trying to figure out and dissect what they're trying to say so that we as the normal person can understand what is happening in our justice system, because holy crap, I'm still going to say this. Regardless of innocent or guilty here, the way that investigations are conducted has to follow a standard and a protocol, and it has to be a process that we should not have to question. Okay? Things being done incorrectly can only lead to two outcomes. Either an innocent person being put to death and losing their life for something that they honestly did not do, or a guilty psychopath who has gotten away with something more than horrendous being allowed to walk free because of faulty police work and corrupt investigations. So when it comes to the way that things were obtained, the way that data was collected, the way that it was looked at, the way that it was sent around everywhere and had all these different hands and minds and touches on it, all of that is extremely important. And if it was all obtained legally and there's no issues, let them see it. But if it doesn't exist, what are they supposed to hand over? That's why I'm curious as to about how all of this is going to end up playing out, because the state cannot force the FBI to do anything. And the way that we're hearing everything is that the state basically only has what the FBI gave them, what the FBI allowed them to have. So if the FBI isn't giving it over, then the state doesn't have it to give over either. And we're at a huge catch-22. But yeah, I want to know what you guys think now that we have all of this to think about. See y'all.